Good morning, everybody. Welcome back to the First District Court of Appeals. The next case on our docket this morning is State versus Mitchell. Ms. Gieske, I'm going to have you introduce yourself to the courtroom, and then Mr. Donovan, I'll have you do the same. Ms. Gieske, if you would. Thank you. Ms. Gieske, if you'd like to step forward to the podium, you will have 15 minutes to argue this morning. Would you like to reserve any time for rebuttal?
Your Honor, I would like to reserve 3 minutes, please.
All right, and please excuse me if I'm looking down at my phone, but I will keep your time.
All right, thank you. May it please the court, Mr. Donovan. This is an intriguing Fourth Amendment case, and I know the judges are familiar with the facts, but for the benefit of the audience, I will very briefly review the facts of the case. And one late afternoon day in July of 2020, police responded to an apartment complex in Ohio. They got a call that 3 men were filming a rap video, and one of whom had a gun on him. So when the officers arrived, they observed 3 people of interest. There was a man in black, a man in a white t-shirt, and the third man who walked away and entered a building. One of the officers believed he saw that third man reach into a Jeep, a white Jeep, before he walked away. So the police entered that Jeep and recovered a .380 caliber pistol from beneath the front passenger seat. The Jeep belonged to Stephen Pollard, who was the man in the white t-shirt. Mr. Pollard did not have any legal disability preventing him from owning a gun. Police also detained the other man, the man in all black. He was also cleared of any wrongdoing. He had no weapons disability. My client's name arose in the investigation when one of the officers got on his cruiser computer and he learned that Mr. Mitchell had used Mr. Pollard's name as an alias in the past. So they decided to try to check this third building. They couldn't get in. And after they cleared the other 2 men, they left the scene. But one of the officers did swear out an affidavit for a complaint, bringing weapons under disability charges against my client based upon that gun found in the Jeep. The next day, a different group of officers went out to arrest my client. Officer Bolte was in charge of the fugitive apprehension unit. And before they went out, so this is where it gets confusing because there are a lot of addresses in this case. So the affidavit for the arrest warrant listed Mr. Mitchell's address as 2670 Lehman Road. But Officer Bolte accessed a database and she noticed that 1932 Kentucky Avenue was a recent address for Mr. Mitchell. So she decided to visit Kentucky Avenue because she noticed that the weapons offense was alleged to have occurred on the same street. She thinks the same apartment complex. So she went there. Her team parked next to this white Jeep that she recalled from the complaint. And after some investigation, they broached a building, 1936 Kentucky Avenue, and they ended up arresting Mr. Mitchell in that building. And when they swept the apartment, they saw some marijuana in plain view. So in addition to the weapons charge, there is a drug trafficking and possession charge.
What was the address on the warrant?
The warrant was the Lehman Road address. So the crux of this case is if Mr. Mitchell was a resident of 1936 apartment 8, the arrest warrant would have been sufficient to enter and arrest him. It is our argument that he was merely an overnight guest at that apartment and that the facts at the fugitive apprehension unit's disposal were at best conflicting. Did he live here? Was he a guest here? Sure. So the office employees at the apartment complex said that they looked at his picture and said, oh yeah, he stays here. They did admit, however, that he's not on the lease. And again, the Lehman Road address is the first address we have. There's nothing in the record that Officer Bolte did anything to research that address to prove or disprove that he did live there or not. When they went to execute this, there was allegedly mail found in the Jeep addressed to my client at this address. However, it wasn't in there. The weird part is that wasn't there the day before when the other group of officers, they found mail addressed to Mr. Pollard, and we don't ever see that envelope. So that's another conflict. And the main theme I'm going to keep coming back to is when you've got these conflicting facts, and I think it is, but I think even, the judge, in all fairness to the judge, she said, I think this is his residence, not a third party, but I invite you guys to revisit my determination because I think she wasn't exactly sure.
So challenging that finding of fact.
I am. We are. And what we would advocate for, did you have a different question, Judge?
Go ahead and answer that one. And yes, I do.
What we would advocate for is that in a circumstance like this, where the officers are confronted with conflicting information, in order to preserve the Fourth Amendment rights of all those involved, it would behoove them to stop, because an arrest warrant is very limited in what it allows officers to do. So under these circumstances,
So while it may be best practices, is it required? Is there a case that you can point us to?
interestingly, so the case law that I revisited over the weekend, the federal case law dances around this issue, but I believe allows for the result that we're advocating for, and here's why. The Payton case says that, okay, you need an arrest warrant to enter a premises, and that's pretty much all Payton says. Then you get to what I think is really the controlling case, the first of two controlling cases, and that is the Stiegald case. And Stiegald says that unless there are exigent circumstances or consent, which we don't have here, the police must obtain a search warrant to seek out the subject of an arrest warrant in a third party's residence. The only reason Stiegald's a little bit different from this case is the defendant in Stiegald was the homeowner. Here, the defendant is the third party. We would argue, though, based upon a subsequent case called Minnesota v. Olson, that that case, the defendant was an overnight guest. And the Olson court said that an overnight guest does have a legitimate expectation of privacy in their host's home. So the logical extension is if you combine the Stiegald holding and the Olson holding, you reach the conclusion that Mr. Mitchell, as an overnight guest, had that expectation of privacy, and that under Stiegald, you need to get that search warrant when you're confronted with these conflicting facts on whose house is this. So, return to my roadmap here. So we do have, and we've got 4 different addresses. And the problem is that, an arrest warrant especially, they're harder to get. A search warrant is harder to get. It's got a much broader reach, but a judge has to issue a search warrant. An arrest warrant can be a number of people under the rules. So we would caution against, this case is a good example of why the differentiation between the 2 different kind of warrants has to be highlighted and they have to be treated differently. Here, the purpose of the Fourth Amendment, the exclusionary rule, this is kind of a textbook case. You want to prevent police overreaching. And in this case, you have the officers who had some information when they got on scene and then as they gathered more information, it actually became more convoluted as to whether he lived here or not. And
get there and then they see it. So, I mean, aren't those 3 pieces, evidence pointing in the direction that
we would argue that the same set of circumstances equally supports that he is an overnight guest there, or at least a short-term guest there. And counsel is right in his brief when he says that we cannot cite the after the fact facts. Like when he was detained and said, I'm having trouble with my girlfriend. I'm here for a little bit. Even if you excise that, even if you take the facts they had and say, yes, these are all true, because the distinction between the arrest warrant and the search warrant is so important, we would say in light of Stiegald, in light of Olson, and in light of the sanctity afforded the home and Fourth Amendment jurisprudence, that when confronted with these kind of circumstances, it's not reasonable for the officers to presume he lives there, to presume the arrest warrant is enough. And
how do we know that he was just my guest without someone just saying, oh yeah, that's my apartment. I live there.
Well, I think that you do need evidence going to that fact, and then we have that here. And the strongest is the rental unit employees. I'm not sure their exact titles, but they seem to be people with knowledge, and they admitted like, no, he's not on the lease, and that's an incontrovertible fact.
Can a person have more than one residential address?
I think yes, you can. Yes, you can. And here, it really goes to what we have to weigh.
What was his status? You know, the letter that was found in the Jeep, wasn't that prior to the warrants being served?
Yes, it was. It was, and again, we don't. I don't like that fact because we don't see that letter anywhere, and the different officer, the different team from the day before pulled only mail from Mr. Pollard out of that Jeep. So we have to presume that overnight, my client came and set his mail in the seat. It's kind of unbelievable. Regardless though, it does not put too onerous a burden on the state to say, under these circumstances, when the evidence is conflicting and all you have is an arrest warrant, you know, they have every right to, the law allows a public felony arrest. So they could wait for him to come out. They can phone a judge, get that. And that is really what we're advocating for, is get the probable cause tested by that neutral and detached magistrate. That allows the greater intrusion. Okay. That really is what we're getting to. You don't have to, there are a lot of rabbit holes you can go down in this case. But if you look at what Stiegald and Olson hold, we are just asking to uphold the sanctity of search warrants of Fourth Amendment rights, and to apply Stiegald and Olson to say that he was, as an overnight guest, he had the same expectation of privacy as the host did, and that required, under these kinds of facts, the police to stop what they're doing, to go to search warrant, and not to broach the residence until they do. I'll reserve the remainder of my time. Thank you.
We need a moment for technical difficulties. Yes, ma'am. Well, I'll be loud enough for the both of us, I'm sure.
I don't know if that'll help us though. It might help you.
Speak softly then. First and foremost, I just want to reiterate that the question here is the facts available to Officer Bolte at the time that she executed the arrest warrant, and that the incursion was made into the apartment. And in my brief, I made reference to that. I believe that there are two incursions here. There's the initial incursion when they forced the door, and then they draw Mr. Mitchell out, and then he is taken into custody at that time. Then, because of his state of undress, he's asked if they want him, if he wants them to get some clothes. Then they go in. That's then when they find the drug. So I would argue that that is a consent search that is separate and apart from this. But to get to the meat of what we're really here to talk about, and I believe that it is like Stiegel and the progeny. In Martin, the Ohio Supreme Court said specifically that Stiegel dealt with a homeowner asserting the rights. And that in that case, the officers went in for the subject of an arrest warrant. They went into Mr. Stiegeld's home, and he was not the subject of that warrant. And they charged Mr. Stiegeld with something. And the court said, you can't do that. And in Martin, the Ohio Supreme Court kind of dodged that issue, but stated that the overwhelming majority of case law out there says that an arrestee, the subject of an arrest warrant, has no greater right to privacy in someone else's home than he does in his own home. Now, there is no binding precedent on this court that says that I'm aware of. The court kind of dodged it. If it's not his place, it's the homeowner. They have to basically I would say that if evidence was collected that went against that person, then they would have standing to challenge the use of that evidence against themselves. However, they would not have standing to challenge its use against Mr. Mitchell. He can't, by transference, by proximity, kind of assert that as well.
If he's at a different location, if the officers came in and extracted without contraband, he can't evict that.
Mr. Mitchell cannot object to that if it is being used against him. The homeowner would be able to. And that's what Martin says. The majority of cases hold that, but we don't need to get to that issue because, and they kind of dodged that bullet. In all the cases, Stiegel doesn't directly address that issue as to whether or not the subject of an arrest warrant can complain about contraband that is being used against him when he is collected in a third-party residence. And I don't believe that it's necessary to even reach that issue as well in this case, because the case law is clear that if there's an arrest warrant, they can enter his residence. They have a limited authority to enter his residence to collect him. And the court specifically and unequivocally found it was his residence. And then if that is supported by competent, credible evidence, then this court defers to that determination. And the competent, credible evidence is the Jeep being found at the location, the Kentucky Avenue, while it was the 1932 is the rental agency for a very large complex that includes 1936. The Jeep that was where the weapon was recovered from is parked out in front of 1936. The rental agent says, yes, I recognize this person from a picture. They reside at apartment 8, 1936. We see them coming and going from that apartment. And
There was some confusion in light of that. What's the harm? They think they've located him. What's the harm at calling a judge at that point? He's not going other than that.
Sure. If we were to go down that road, and there would need then be exigent circumstances, and we'd have to make that argument. The question I would pose, or I would change it in terms of while there might potentially not be any harm, is it an obligation? Were they obligated? And I believe, Your Honor, that you had brought this point up. Or actually, it might have been Judge Zias.
2 residences?
In terms of the 2 residences, but also whether or not they're obligated to resolve those conflicts. And the officers clearly, in their opinion, resolved that conflict in believing that, rarely are we ever going to have something that is 100% absolutely everything points to this one thing. As a prosecutor, when I see that in a case, and when somebody says that's the case, that's a warning flag to me that somebody might not be quite telling the truth. Yes, there are multiple residents or addresses that are referenced here. The search or the arrest warrant does say the Lehman Avenue address. But that's why the officers who are in the fugitive apprehension unit then use the CLEAR database to determine that there was a different address, the Kentucky Avenue. Well, that links up with the offense that they're arresting the person. That occurred. And so I think in resolving those conflicts, while it certainly wouldn't have been inappropriate for them to back off additional search, to do additional research or to potentially get a search warrant, I don't believe that under the law it was necessary. Court found that it was his residence. We believe that that determination is supported by competent, credible evidence. And so The question then just comes additionally, in making that finding, the court is finding that the officer had a reasonable belief based on the totality of the circumstances available. We have to remember that Officer Bolte was not involved in any way in the incident from the day before, had very limited knowledge about that. Her knowledge about that was that a gun was recovered, that it was attributable to this person, that it was recovered from a Jeep parked at this location. Lo and behold, they find that Jeep. It corroborates her belief that the Kentucky Avenue apartment complex is the residence. The rental agents then verify that and corroborate that.
As I understand it.
Yes.
Students.
Yes, ma'am, I will. In terms of allied offenses, whether there are separate and identifiable harms from the different charges that are raised, the case law is very clear that possession and trafficking, when they arise from the same contraband that has been collected and from the same act, the case law is clear that those cannot sustain separate convictions. And of course, as the court is well aware, a conviction is both the finding of guilt and the sentence. Yes, he was found guilty of both possession and the trafficking, but in terms of sentencing, he can only be convicted of the one. So when the court, and there was some minor discussion of allied offenses in it, I believe that everybody kind of got sidetracked with talking about the Fourth Amendment issue and let that slip. I believe that it's a clerical error, but indeed the sentencing entry does reflect conviction for both, and that cannot stand. So it must be sent back for the state to elect which of the two charges. I would argue that we will elect the trafficking charge to go forward. Then, in terms of the forfeiture, the law is clear that in order to forfeit a weapon, there are certain specific steps that must be taken, one of which is that it has to be specifically identified. The court's entry that firearms are to be forfeited could encompass, while he cannot, under disability, he cannot possess a weapon, he could still have ownership. Ownership and possession are two different things. He could own them and they belong to somebody else. Under the court's order, any firearms that he owned would then be forfeited, and that is clearly contrary to law. And we agree with counsel as to the second assignment of error that the trial court erred and that it must be remanded for resentencing to reflect the law. Yes, sir.
Is it your position that there was consent to what you're calling the second search, the first incursion comes out and then it's closed? Are you saying that there was consent attempted to going in to get the close, or?
That is the argument that I made, that it was with his permission that they went in. So in the initial incursion, and you know, with all due modesty, he was in a state of undress. I believe that he had a towel or a blanket over his shoulders and nothing else. And they took him out onto a public landing. Because it was a gun run, the officers had their riot shields and did not enter the apartment. They kicked open the door. They saw him, they ordered him to come out. He came out onto the landing. They took him into custody. They then, because of his state of undress, asked him if he wanted that. They could take him down to jail in that state, but they asked him if he wanted to get them to get him some clothes, and they explained that they would have to clear the apartment to make sure that nobody was in there before doing that. And it was during that time, there wasn't specific testimony as to this, but evidently it was during that time that the contraband was discovered. And so, yes, that is our position, that they asked him if he wanted some clothes, and they explained, we got to go through the place in order to do it. And he said, yes, he wanted some clothes. I get it. He's kind of between a rock and a hard place there, but that's by his own doing and not by action of the state. But even if this court were to look at the two incursions as one constant, both under the case law, we believe that the competent, credible evidence supports the trial court's finding that he resided there and thus supported the, there are no further questions. Thank you, Your Honor.
Thank you, Your Honor.
Was there consent to do that protective sweep?
I do think that is a closer call. He's kind of between a rock and a hard place. So is saying yes, go get me some clothes, automatically saying yes to having a look around? I'll say not necessarily, but I don't think we even need to get to that issue because the way the exclusionary rule operates, if the first search was unlawful, everything that follows is excluded. So that's a closer call that fortunately I would love to sidestep. Really, what this case comes down to is that under circumstances such as this, now the Martin case, what's important to mention is that that was not an overnight guest. So there was no reasonable expectation of privacy in that case. And that does make all the difference in this case. This was a big apartment complex. We have 3 different addresses on Kentucky Avenue. Do you want to hold that officers armed with an arrest warrant have carte blanche to go to an apartment complex and search anywhere and everywhere that the suspect might be? And I think obviously the answer is no to that question. Sort of, because we do have 3 different Kentucky Avenue addresses confronting the officers and the Lehman Road. That he might, you're correct, that he might. And from the Payton case, the limited authority inherent in an arrest warrant, that case says that does not free the police to search for a suspect in anyone's house without obtaining a particularized judicial determination of probable cause to believe a particular person is in a particular place. And that really is the crux of this case. Was he there? Was this his residence? Maybe, maybe not. It's hard to tell from these various facts. We do not want to incentivize the police to, for example, say like in Stiegel, that was the homeowner. So do you want to say that the officers can go in and as long as they leave the homeowner alone and they only arrest a third party, we shackle the third party's ability to challenge evidence that he is then indicted on. And here, that does like circumvent the whole purpose of the Fourth Amendment to not just redress, but to prevent this subjective police overreaching in the moment. Okay, so we would ask for the court to reverse and remand with instructions to grant the motion and at a minimum to reverse and remand for resentencing. Thank you.